Good morning, and thank you for being here today. I am Danielle Pollack, Ambassador of Child USA. I lead the organization's Family Court Reform Initiative, and I advocate for policies and laws which strengthen evidence-based solutions and information that is needed by policymakers, organizations, and society as a whole to increase child protection and the common good. In Connecticut, there are nearly 40,000 victims of domestic violence each year. Nationally, approximately 15 million children each year are exposed to domestic violence or child abuse, which are interlinked. The next speaker, Evan Stark, who wrote the book on coercive control, will talk about how domestic abusers are network abusers and that their abuse spreads out to everyone in the abuser's network. So if they're hurting mom, they're hurting the children. Child sexual abuse is significantly underdocumented and underaddressed in our legal system. One study shows that female children whose fathers abuse the mothers are 6.5 times more likely to be sexually assaulted by their fathers than are girls from nonviolent homes. So it's a network offense. If they're abusing the mom, they're abusing other people around them. Maybe not directly physically, but they're creating harms in the network of people around them, including the children. The harms of domestic violence, including partner violence, child abuse, and child sexual abuse, also cost us an incredible amount of money. If we look at total lifetime estimated financial costs associated with just 1 year of confirmed cases of child maltreatment in the U.S., so including physical child abuse, sexual abuse, psychological abuse, and neglect, it costs us $124 billion nationally a year. So even if you don't care about children, you just care about money, you should care about this issue. This is a major public health issue, and most of the abuse is happening in families. When protective parents finally manage to exit abusive homes, taking children with them in an attempt to keep them and themselves safe from the abuser, they may find temporary relief. They may find another home if they have the means, or stay with friends or family, or go to a domestic violence shelter. But the next step on their path is almost always treacherous, because that is when they must enter family court. And there, protective parents discover that they and their children will very likely be court-ordered into ongoing contact with the dangerous abuser they worked so very hard to escape. You can't ignore a court order. That's breaking the law. So if the court is ordering you to send your children to someone you know is violent and dangerous, and the court doesn't believe you when you're telling them, this person is dangerous, he's doing X, Y, and Z, there's nothing you can do as a protective parent, because you'd be breaking the law if you didn't follow the order. Thousands of protective parents every day must send their children to be in the unsupervised care of someone they know is very dangerous. This is what happened last year in Pennsylvania, where 7-year-old Caden Mancuso was brutally murdered by her biological father while on a court-ordered visit with him. He was awarded this access to the child despite a history of violent and erratic behavior and pleadings and warnings from the protective mom. She told the court, he's dangerous. Family courts far too often minimize and disbelieve protective parents' claims of domestic violence, child abuse, and child sexual abuse, even though we know that it is in families where the majority of child maltreatment occurs. Instead, family courts strive to keep children connected and bonded to parents, even when safety concerns are raised. If both parents are fit and not abusing, this is, of course, best for the children to have these relationships with both parents after a divorce or separation. But the majority of litigated cases in family court have a family violence component, about 70% of them. So the cases that are arriving before the judges, about 70% have a family violence component, either adult on adult or adult on child. This means that family court is an opportunity to curb and stop these harms. but they're not doing this job adequately. They're believing protective parents only a small percentage of the time. We know from a new nationwide study, which Betsy mentioned, it's from Joan Meyer at GW Law, courts only believe claims made by protective moms at a very low rate. Only about 21% of time for child physical abuse, and even less often do courts believe protective moms for child sexual abuse claims, only 19% of the time. It's very low compared to what we know about incidence rate. Courts are somewhat more likely to believe claims of adult-on-adult violence, what's traditionally called domestic violence, but it's still quite low compared to what we know about incidents. Because in practice, family courts across our nation currently do not prioritize child safety, in practice, so in language they do, but the way that it plays out, as many moms here can attest, it doesn't work that way. Children's safety is not prioritized to the degree that it should be. And this creates unnecessary intergenerational harm and immense social cost. And we at Child USA and several of my collaborators, including Joan Meyer and Richard Ducote, are working to change custody laws and protocols around the country. The principles we apply are those adopted by Congress in 2018 House Resolution 72. Foremost, that child safety be the first priority of custody and visitation adjudications, and that state courts should improve adjudications of custody where family violence is alleged. Model legislation has been passed in Louisiana. We're advancing important legislation to do this very thing in Pennsylvania. It's nicknamed Caden's Law after Caden Mancuso. Maryland has formed a legislative work group to address this. There's a big movement for reform, for family court reform in California and several other states at this moment. And Connecticut now can lead with this bill that Senator Bergenstein will propose. This is an opportunity for Connecticut to sort of catch up and be at the forefront of the reforms that need to take place in family court so that children and their protectors are properly protected and not hurt. We know that 730 U.S. children have been murdered by a divorcing or separating parent over the last decade. 730 U.S. children killed by their parent who's divorcing. And 73% of those 730 kids, they were murdered by the biological father. So there is a gender component to this. This is unacceptable. This is the moment for change. It is time for children and their protectors to have their civil and human rights. They should not be ordered to be in the care of someone who's hurting them. And their protectors need to be heard. It is time to prioritize their safety above all else in our courts and in our society at large. It is time to believe children and their protectors. Thank you very much. The next speaker is Evan Stark. He's a world-renowned author and leading thinker on coercive control. And he's going to talk about several things.
I don't know if I can do this. If I disappear. Excuse me. I also have no voice. Good morning. I'm not sure, Alex, I apologize, you have to sit through all this. I'm sure at the legislature it's, I don't know, I won't say it's more interesting, but at least you can sit down and drink water and look at you. I think what I'm going to do this morning, I don't know what to do in 10 minutes or so, but I think what I'm going to do this morning is just sort of tell you the big context in which we're winning. Because when I speak in England these days, or in Scotland, and last week I was in Australia, we fill football stadiums. We fill football stadiums with police, prosecutors, and women's groups, because we have the law. But I want to tell you something, too. I'm going to tell you that the law is not the answer. It's the coercive control context that makes the law work. It's my police spending 2 years tracking a guy on a surveillance system that I have centralized through the central prosecutor in Edinburgh, who can track these guys because they move, they run. They take their kids and they go from house to house, from town to town. I have police who've been in the same borough for 25 years. They don't have the manpower, the woman power to follow them. I need to have surveillance equipment. That's the coercive control context. That's a commitment. I have the deputy commander of all the Irish police, when the day before we introduced the new coercive control law in Ireland, I was briefing the chief police officers in all of Ireland, and I was just listening. I said, I'm just going to listen. They knew that wasn't true. And so finally one of the chief of detectives got his dander up and he said, oh, Dr. Stark, what am I going to do? Am I going to tell that man who's the guy's running down the street with the TV set? I'm going to say, let him go with the TV set. Go check the domestic violence. What am I going to tell my officer? And the woman who's the chief deputy commander of all the police in Ireland turned to him and said, you tell him, young man, you're bringing liberty through the door. That's what coercive control is about. It's not about domestic violence. It's not about child abuse. It's about liberty. And that's what this family court discussion is about. It doesn't start with liberty. It starts with little things like custody. It starts with little things like alimony. But the fundamental principle about which all of us are concerned is that people should have equal rights to liberty and equality and dignity, and that is on the table. And by the way, it's on the table for children as well as women. My new book, which I recommend highly to you, will be out in about 6 months, it's called What About the Children? 40 years ago, about 30 yards from here, Ann Fletch-Griffith and I published research that showed domestic violence was the leading cause and context of child abuse in the United States. Men, not women, are responsible for more child fatalities and near fatalities, 60 to 80%. Do you know that? And wouldn't you believe it? Isn't it a strange fact that there's not one child welfare department in the entire United States that has a division that focuses on men as the abusers of children? Even that's why, when we brought the lawsuit, Nicholson versus Williams, against the state of New York was found unconstitutional. The federal court in New York found that the city of New York was violating women's 9th Amendment, 15th Amendment, and 13th Amendment rights, including their right to indentured servitude, by taking their children away from them and putting them into foster care solely because there had been domestic violence in their household, even though they themselves had not committed the domestic violence, and their children had in no cases, not one, been themselves abused. Indentured servitude, they said, the city of New York, the Division of Child Welfare. Well, that is what the family court does in the state of Connecticut. When it takes children and it gives them to men who have committed domestic violence, it puts those children into indentured servitude. It takes away their right to liberty and dignity, and the children tell me that. The 3-year-old children tell me that. The 5-year-old children tell me that. My office, the 9-year-old girls tell me that. And do children lie? Oh, you bet they do. As I told the judge in Baltimore, not only did this girl lie to me about seeing her father abuse her mother, I'll tell you why she lied. Because she'd been trying to get somebody to take that abuse seriously. Because it's not what they see. It's not only what they hear. We're learning to stop using words like witnessing child abuse. Children don't witness it. Joe Torre of the New York Yankees told me that when he would come home, if he would see his father's car in the driveway, he would go to a neighbor's house. He knew his sister was home because he knew his father was beating his mother. And when he told me that story, Joe Torre, world champion New York Yankees, I know he went to some other teams, But world champion New York Yankees broke down and started to cry. He didn't witness domestic violence. He experienced coercive control. What we now know is that domestic violence is not a one-on event. It's not a single instance. 70% of the cases, it goes on for an average of 5 or more years. That's what you're seeing in family court. That's why it's so hard to produce evidence of a photograph or an X-ray or a letter or a document, something, because it happens not only behind closed doors, but it happens in the insidious, invisible ways that you can't see always or feel or touch, but you experience as deeply as you experience any kind of insult to your dignity and your liberty. So we're learning that coercive control is something, first of all, that embraces, as she was saying, an entire network. Not just a network of the family, not just the children and the women, but the neighbors, the friends, the in-laws, the grandfathers. We have whole Irish families. We have whole networks of police officers, 3, 4 generations back down here in the valley in Waterbury, which have been involved in 1 or 2 or 3 domestic violence cases for years. Networks are committing coercive control, not just individual men, and they're committing against all of the women and children in that family, boys as well as girls. This is not only a network offense, it's an offense against the network. It's an offense against the entire community, and it's visible. All right, I could go on and on like everybody else here at this point. Let me just tell you what we've done. So first of all, we took a member of parliament named Bill Walker in Scotland, and we put him on trial for 15 assaults against 3 wives and 4 children. And as a result of years and years and years of domestic violence, Judge Mackey could only give him, she found, a maximum of less than a year in prison. It wasn't even enough time for him to have to give up his seat in Parliament. And so Judge Mackey did what only the bravest of our magistrates could do, a family judge. She stood up and she said, I will give him 15 years in prison, but I can only give him 364 days. What we need is a new law, because he is guilty of all of these accumulated assaults, hitting his 15-year-old stepdaughter with a frying pan. The insults, of course, he said what every barrister says. He said, well, it was a conspiracy of the wives. You know, the wives were up against me and the stepdaughter. And the next day after Judge Mackey gave that speech, the Scottish Parliament voted unanimously to pass a new domestic violence law, coercive control law, enumerating a maximum penalty of what? 15 years in prison. Not 30 days, not 60 days, not 1 year, but 15 years, because the coercive control included all of the domestic violence accumulated over time because of its accumulative effect. A woman who lives with that doesn't get banged once, banged twice, banged 3 times. She gets the accumulated insult of all of that hitting, accumulated in fear and trepidation and deeply down in the soul. So that is the 15 years. And then the sexual abuse and the isolation and the child abuse is contained in that felony crime, because we understand that the children are always part of it. Coercive control of the children and coercive control of the woman are part and parcel of the same thing. You can't separate out the cases the way we do now in family court. This is just the beginning, so we passed that law. And we did the same thing in England with a different case. 16 children killed in care with their fathers, to whom the family court had given them in 1 year in London. 16 children were killed while they were being cared for by their fathers, whom the family court had given custody. And so Theresa May, who was then the Home Secretary, not yet Prime Minister, not yet Brexit, adopted coercive control as a whole national definition for all of England, subsuming all other definitions, and immediately the world was transformed for domestic violence victims. No longer was there a revolving door in the police departments with men who were arrested on Friday night for domestic violence would be out of jail Saturday morning. Now people are going to jail for 4, 5, and 6 years on accumulated counts. And we were clearing the dockets because 40, 50% of the cases our cops were seeing were repeat offenders. Now the repeat offenders were getting single unified crimes. Now Nigella Lawson, you know who Nigella Lawson was before, was coming forward and saying, I am psychologically abused. And her partner was being put on trial because that too is thought to be an insult to the dignity of liberty of people, anything that devalues your equality and your humanity. And so now we're coming back, I'll just tell you that. And you heard we have laws now on the books coming on in Louisiana, in Colorado, in Minnesota, in Wisconsin, in New York, in Pennsylvania, in California. We have to move very slowly and state by state in this country. And we're just beginning to get criminal laws on the books. We're beginning to move now in the family sector too, because we realize that's important. And the third arena I just want to mention, because it's important even though it doesn't affect you, I've just come from a prison in Miami. That's where I was 2 days ago. And last week I was in a prison in Wisconsin. And that's where people like Jennifer McDaniels would have ended up had she not herself been killed because her children were taken away. These are women who have been battered, whose children have been murdered by their partners, and who themselves are being charged as co-conspirators because they didn't get out. Not because they hurt the children, because they didn't get out. And I am able to free one after another of those women, just like we freed Sally Challen in England. Sally Challen hit her husband 28 times with a hammer. He was dead after the 5th time. And she kept hitting him. And she had been in jail for 8 years before I explained to the High Court of Appeals that it was those other 23 times that she hit him that made up for all of the indignities, because there had been very little violence in that case, that made up for all the times he'd taken her money. There had been almost no violence in that case. All the times that he had treated her as an equal, she had lodged into those hammer blows. And when Sally walked out of the courtroom a free woman, 3 days later, England understood that there's a three-prong. There's justice for women, because women cannot be charged for things that are done to them or done to their children because we have failed them, and because the family court has failed them. Because if the family court fails them, some of the women who are in this room will be in those prison cells 2 years from now, I guarantee that. Because they are just like you. They look just like you. They look just like us. And the second prong, of course, is the criminal justice prong. We have to hold these men accountable. And it doesn't mean that all men are accountable, but it means that the men who are serial batterers, the ones we are seeing in family court says we see the least serious ones. No, we see the most serious cases in family court, because these are the cases where the women have stayed, where the women have the resources, and the women have the education, and the women have the wherewithal and the courage and the dignity to stick it out and try to make it work. And these son of a bitches know how to be con men at the highest level. These are the most serious cases, not the least serious cases. The other women say, well, I didn't expect much in life. They get out at the beginning. So the family court is the second arena, and the criminal court. We have to hold these men accountable, and then we have to have the equity. Equity means we have to restore children and women to their place in the community with the full protection of the law at their back. And that's what we're here to do. So if we can guarantee women justice, if we can guarantee men accountability, and then we can get real equality in front of the law with new laws like the one here in Connecticut that you will now talk about. Thank you.
Thank you, Dr. Stark. Oh, sure. Change your microphone. Thank you, everyone, so much for being here. Domestic abuse is an abuse of power by one person over another person that happens in every state and in every zip code. It's time for Connecticut to take the lead on addressing it. I'm State Senator Alex Bergstein, Vice Chair of the Judiciary Committee, and I represent Greenwich, Stanford, and New Canaan, Connecticut. Jennifer Doulos was my constituent. The Doulos divorce case had hundreds of motions filed in family court over a period of years. Such cases are often labeled high conflict, but that's a misnomer. These cases are often the result of abusers weaponizing the legal system to harass, intimidate, and destroy the person who dared to leave. We stand here today seeking justice for Jennifer and for all the women and children whose lives have been lost. Though we can't bring any of them back, we can work to ensure the safety of those who are still alive and suffering from abuse. Domestic abuse is a pattern of behavior used to dominate, control, and intimidate a partner into submission. It can include physical violence, sexual assault, litigation abuse, and other recognized forms of abuse of power and control, such as coercion and threats, intimidation, male privilege, a master-servant dynamic, economic abuse, taking her money, not letting her know what's coming in or what's being spent, controlling the children or threatening to take them away, denying abuse and shifting the blame to her, emotional abuse, humiliation and gaslighting, and isolation, limiting her contact with others. The fact is that abuse is underreported. Women in abusive relationships are scared into submission, and when they do find the courage to leave, they are intimidated into silence by a legal system that penalizes them for telling their truth. When abuse is reported, the credibility of the victim is immediately attacked. And when the credibility of one woman is under attack, the credibility of all women is under attack. This is institutionalized gender discrimination. The shocking truth demonstrated by Joan Meyer's research, as well as the lived experience of so many survivors, is that mothers who are victims of abuse are less likely to gain custody, while fathers who abuse are more likely to gain custody. Moms lose custody 3 times as often, even when abuse is proven. Today, we are shining a light on this bias against women and pledging to end it. We are not trying to tip the scales of justice, but rather to create a level playing field so that abuse is neither rewarded nor tolerated in Connecticut. Other groups have spoken out about domestic violence, and I'm grateful for anyone working to protect victims. But the only proposed remedy I've heard so far, educating judges, is simply not enough. To truly fix this, we need to take a close look at our court system and answer hard questions, such as, why is the standard for obtaining a restraining order so high in Connecticut? Why do most abused women have no legal representation, making them 50% less likely to obtain a restraining order? Why can abusers in Connecticut file excessive and frivolous motions that serve no legal purpose? Why can abusers, or anyone for that matter, defy court orders in divorce cases? Why is domestic violence handled separately by civil and criminal courts? And why doesn't Connecticut have a dedicated domestic violence court with highly trained judges and an Office of the Victim Advocate to supply critical legal support and other services to victims? All of these questions must be addressed, but today we're focusing on one problem area, child custody, and one solution. Let's remember that an abused woman often stays only because her abuser has threatened to take her children or harm her in other ways. She feels powerless and paralyzed by fear. If she can summon the superhuman strength needed to leave, that is when danger peaks. Because when he can no longer control her, the objective is to destroy her. Abuse is a powerful and often invisible force that must be recognized as the paramount factor in the safety and well-being of women and children in these situations. Currently, the Connecticut statute regarding child custody, 46B56, requires courts to consider domestic violence and child abuse among the 16 factors in determining best interests of the child. We believe abuse is the most important factor and should be determined first, because it's the overarching element that explains so much about the family dynamic that might not otherwise be apparent. And Congress agrees. Today, I'm proposing the Child Safety First bill, which mirrors what Congress has already urged every state to do. Congressional Resolution 72, which passed with bipartisan support in 2018, states that family violence and abuse must be considered before other factors in custody cases, and courts must rely only on experts trained in abuse and trauma to make their determinations. Making abuse the first issue evaluated in custody cases would show judges what's really going on inside a family and clarify what's really in the best interests of the children. I want to be clear that this is not a campaign of women against men or moms against dads. Any person, regardless of gender, can be a loving parent. And many divorced couples are both loving parents. But when a person has a history of controlling abusive behavior, they can no longer be presumed to be suitable for the custody of a child, which is what our law currently allows. Today, we're advocating for the rights of children to be safe and loved. We're advocating for the rights of women to be heard and believed. And we're advocating for the rights of everyone to be in safe and healthy relationships based on dignity and respect. Thank you. I have copies of the proposed concept bill, which has been put in all of the press packets, and I'm happy to take questions if anybody has them.
What's the next step moving forward to try to get this bill passed?
So the next step is that I have spoken with my colleagues, the leadership of the Judiciary Committee, and let them know that this is something I'm pursuing. I will now send them an official letter with this concept bill attached, and I hope that given the public's support and awareness of this issue, that they will take it seriously and that they will propose the bill. In this particular session, this is called a short session in the Connecticut legislature, individual legislators cannot propose a bill, only committees can introduce bills. So it would really be up to the leadership of the Judiciary Committee. Yes?
Hi. The currently custody is based on the best interest standard in Connecticut, and in the best interest standard, there is nothing that provides for health, safety, psychological well-being of the child. The judge can pick from any one of these points, say the spouse who left the house first gets preferential treatment because they didn't want to cause a conflict, and you prevent from conflict. So does this bill address the one issue that is paramount in a judge's decision, the best interest of the child, which includes nothing for safety, health, and well-being of the child?
I think this bill is a first step. So obviously, the safety, health, and well-being of the children is of paramount importance, and that is actually what the preamble to the bill would say. But it's just a first step. There are many issues, and that's why I read a list of just some of the questions that really need to be answered in Connecticut court system, because there are many gaps and issues that need to be addressed. Yes.
Hi, I was particularly interested in what you said about the experts trained in abuse and trauma. I'm a journalist at USA Today, and I covered the AFCC conference up in Toronto for a project, and I did hear Linda Gottlieb, among others, speak, and I think she worked for Child Protective Services or something, and she would be an expert, not an expert, certainly a lot of folks in this room would agree with. So, like, how would you get around that? I mean, there are experts who believe children routinely lie about child sex abuse. How do you
Yeah,
become an
well,
expert in a way that protects you?
there are bad actors in every field. We'd have to, look, this is the beginning of a long and complex process, and that would have to be examined very closely. And there should be accountability for bad actors in any profession, and people who are not upholding the standards, the true standards of their profession.
If you don't mind me asking, did you have a point? Oh, he was asking, could I just...
Do you want to answer the question? Oh.
I had a follow-up.
Okay.
So when along those lines of what you just said, I know California advocates have had some great success in getting, I don't remember if it was exactly the Board of Psychology to get them to discipline people, but they did change something in the Board of Psychology to actually get rid of bad actors. Is there anything like that going on in Connecticut?
I'm not aware of that happening yet, but that's something that would need to be built out, and we need a system. We need a comprehensive system. This is just the beginning of a broader solution, which would have accountability at every level, including accountability for judges. Yes, sir.
Ma'am, how exactly would the bill reduce the kind of ugly, frivolous, drag-it-out violence that you mentioned?
Yeah, that's a great question, because I've asked judges that. I've asked judges in Connecticut, what is the standard in Connecticut for frivolous motions? And the answer I got was, well, they have to be frivolous. And which means there's really no standard. And that the answer I got was that, well, everybody's entitled to due process. Yes, everybody's entitled to due process, but there have to be limitations. Due process cannot be used to harass, intimidate, and destroy somebody else. And by the way, this is at the cost of all Connecticut taxpayers, because our courts obviously are funded by taxpayer dollars. So a small percentage of cases, these high conflict cases, consume an enormous amount of judicial resources. So every taxpayer in Connecticut should be very concerned about cleaning up the system so that, again, so that individuals who have their own axe to grind are not using the court system, which is a public resource, for their own personal sport. Evan.
Did you not use the language of presumption of custody if there's a finding? If there's a finding of domestic violence?
Yes.
Does your bill call for the presumption of custody then to be given to the victim?
Yes.
It does.
Yes, I can read that. A presumption against custody for any parent with a history or demonstrated pattern of domestic violence or abuse, or any parent who has subjected a child to sexual abuse.
So that, now, wouldn't that in itself address a lot of the ambiguity that the family court now has? Because 45% of the cases are domestic violence cases, and even half of those cases are triaged off because of the
Excellent.
almost overnight. No, well, it's not so good for some of the judges who should be retired, but it certainly would create a lot of thinking.
Yeah. Well, ideally, we'd have a dedicated domestic violence court with highly trained judges with all of the support services and staff needed so that we didn't have untrained judges or judges who are inexperienced in this having to decide what really are life or death issues. Yes, sir.
You said that domestic violence is currently one of the series of factors considered in custody cases. Are those prioritized in any way at this time?
No,
So it's just a list and they can choose?
it's a list. 46B 56 of the Connecticut General Statutes. It's a list. And I have a copy of it if you want to see it. Yes, Amanda.
So I'm sure you wouldn't be surprised to hear we received comments about this upcoming legislation from Mr. Davis's lawyer, and
Mhm.
I'd like to give you the public opportunity to respond to it. That's something that you're interested in.
Yes.
Well, his criticism was that using Jennifer's disappearance to advance legislation change is near crisis moment, and hysteria is not a sound basis for public policy.
So this is a crisis. Domestic abuse and domestic violence has been a crisis forever. We are shining a light on it. And I would say that anybody who uses the word hysteria in the context of speaking about a woman is attacking the credibility of all women.
Well said.
Yes.
And maybe as a follow-up to that question, what would be the single-focused activities people in Connecticut to do as constituents to make that in court happen?
Mm-hmm.
From the bottom up, what can we do?
Yeah, well, from the bottom up, everybody can call their state representative, their state senator, and tell them that they're supportive of this bill and of further actions taken to improve the outcomes and the fairness of family court. Evan.
I just want to tell you this, about the domestic violence courts are not a panacea. They have been existing in New York for many years. They existed in Wisconsin for a number of years. There are a number of other places that happened. First of all, they can be on the criminal and on the family side. Typically, if they're on the family side, they don't have criminal jurisdiction. And so when you're dealing with a problem like domestic violence, when you're dealing with evidence that bears on multiple criminal offenses, in most cases, the family court has very limited jurisdiction and very limited power. And what has happened in most cases with domestic violence courts, like in Westchester and New York, is that the judge is at so low level of jurisdiction that he can't handle anything but low-level misdemeanor crimes. Most domestic violence crimes, when you enumerate them as they've actually occurred, are considerably more dramatic than it can be handled, even at a high-level misdemeanor such as New York anticipates in 1 year in prison. So the family court, the domestic violence court, triages those cases, doesn't handle them very well. And the judges have moved very rapidly through because they get burned out, they get very frustrated. What I think I would suggest is that the next order of business with the bill that prioritizes domestic violence is to craft a definition of domestic violence
Yes.
that's broad enough that it encompasses the experience that the women in this room have had, so that you're dealing with all the issues that you raised,
Yeah.
isolation, economic abuse, but also child abuse. In other words, recognize that coercively for children, rather than witnessing children, is part and parcel of the way in which men abuse women.
May I read my definition? Okay. Which, of course, is subject to expansion. The statutory definition of domestic violence and abuse is revised to include a history or pattern of coercive, controlling behavior, including but not limited to physical violence, sexual assault, financial abuse, litigation abuse, and psychological abuse, including but not limited to isolation, stalking, harassment, intimidation, and threats regarding the safety or control of children. So we can expand the definition, but again, this is about reframing the issue so that it's not simply, domestic violence and abuse is not simply thought of as a strangulation or a punch that leaves a bruise. We know that so much of abuse happens with no visible signs. And as Professor Stark said, the damage is insidious, and it pervades the whole network within the family. Okay, if there are no other questions, thank you so much, everyone, for being here.